All right, this is Clayton County preliminary hearing calendar. Today's date is March the 18th, 2026. The matter before the court is the state of Georgia versus Tony Kennedy Nolan in warrant numbers 2024 CW 51360 and 2024 CW 51361. All parties are present and have announced ready to proceed. 88 Thomas, you can present the state's case.
Thank you, Your Honor. Officer Arnett, can you hear me?
Yes, ma'am. Can you hear me?
Yes.
Okay.
Can you raise your right hand, please?
Yes, ma'am.
Do you solemnly swear and affirm that the evidence you should give before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
You can put your hand down, state your name for the record.
Liliana Arnett.
And how are you currently employed?
I'm currently employed with the Secretary of State as a special agent.
Now, on June the 4th, 2024, how were you employed?
I was employed with the CID commander of Lake City Police Department.
And in that capacity, did you come into contact, first of all, did you come into contact with were you involved in an investigation involving a Tony Nolan?
I was actually involved. I got involved on the 5th, on June 5th. I made contact with, Yes, I did speak with Tony Nolan. I spoke with Tony Nolan on the 5th, and then on the 4th is when I spoke with the victim, Mr. Paris.
Okay. And is this regarding an incident that occurred on the 4th at 1885 Harper Drive?
Yes.
And is that within the confines of the city of Morrow, Clayton County?
Yes, ma'am.
Now, how did you become involved in this incident on the 4th?
I apologize. Both the incident, I became involved on the 5th because the report was turned over to me that morning. I contacted Mr. Stanley Paris, the victim, who stated that he met a person online from the cell site OfferUp. He made arrangements to meet him at the Quick Trip located at 6801 Mount Zion Boulevard in Morrow. Paris stated that when he met the person there, who was later identified as Tony Kennedy Nolan, that Mr. Nolan was bringing him a Steam Deck. A Steam Deck is similar to because I had to look it up myself. I didn't know what it was. It's similar to a computer play game station. It's handheld, and Paris agreed to get in the car with Mr. Nolan because Mr. Nolan stated that he forgot the Steam Deck. He left it at his house.
Okay, let me stop you right quick because I know you're on a roll and I apologize. You mentioned something called OfferUp. What is OfferUp? OfferUp
is a sell site, SELL. I'm sorry, I did say sell site, but I maybe said that too fast because it's a sell site similar to like Marketplace.
So you can put items on for sale and people can purchase them if they desire.
Yes, and like eBay and everything else, you can meet up with them, or Marketplace similar to that. Yes.
Okay. Now, did the victim make arrangements on that site to meet this defendant?
Yes.
And it was for the sale of this item, a Steam Deck, whatever that is?
Yes, ma'am.
Okay. And I believe when I cut in, you were saying that the defendant asked the victim to go with him to get the deck, that he had left it somewhere else?
Yes, ma'am.
Is that what the victim did?
Yes.
Now, what happened next?
So they drove to the flats at 1885 Harper Drive in Lake City, Georgia, Lake City, Morrow. It's Lake City, but we don't have a zip code there in Lake City. And then at that point, when they pulled up to building 25. Nolan.
What is the flat?
The Flats is an apartment complex located at 1885 Harper Drive.
Okay, now when they got to that location, what happened?
They pulled up to a building, building number 25, which is closer to the like Rex Road, where Harper Drive and Rex Road come together. And when he pulled up to the building, the victim, Paris, stated that Nolan talked to some child and then Paris got out of the vehicle and realized he left his phone in the car because he doesn't have his phone set up on lock, and turned around to go get his phone. And he noticed that Mr. Nolan was on the phone and had taken over $2,000 off his PayPal account and transferred it to a debit card. And then when Mr. Paris went to grab his phone, Nolan pulled out a pistol. He said what he believed to be a Glock and pointed at his head, saying, "I'll bust you. I'll bust a cap in you." Paris stated he grabbed his phone, and as Nolan was pulling off in his Dodge Charger, Tony Nolan dragged him approximately 75 feet, causing injury to his feet and hands.
Did you observe that?
Yes, the injuries were documented and pictured, and they were ambulance was also called for him, and he was bandaged up at the time.
And you say an ambulance was called for him, I'm assuming at the scene?
Yes.
Now, was the phone snatched from the victim, or did the victim give the phone to Mr. Nolan?
Mr. Paris stepped out of the vehicle after the child. Mr. Nolan spoke to a child to see where he was going, because he started to get a little suspicious at that point. And then he turned around and realized he left his phone in the car, which was not locked. He didn't have password lock on it. And he saw that Mr. Nolan was on his phone. And then he realized that over $2,000 had been transferred to a debit card to Mr. Nolan from Mr. Paris's, I believe, PayPal account.
And at that point in time, had Mr. Nolan used a weapon or anything, or he just snatched the phone when the victim wasn't looking?
Mr. Nolan, when Mr. Paris went to snatch the phone from Mr. Nolan back and get his phone back to keep him from taking any more money, that is when Mr. Paris stated Mr. Nolan pulled out a weapon, and it looked similar to a Glock, and stated, "I'll bust a cap in you."
And he pointed that gun at the victim?
Yes.
Was the victim able to get his phone back?
Yes, he was.
What about the money?
No, as far as I know, no, because Mr. Paris turned off his account for the site OfferUp. So at that point, he wasn't able to get anything back, because he's not able to contact OfferUp to cancel the transaction.
To date, has the victim gotten his money back?
I have not spoken to the victim since that date, since I took this job almost 2 years ago now.
Okay.
I have a question. So he allegedly transferred the money through the OfferUp account, or he opened like a banking app on his phone and transferred money?
He transferred money to his to a debit card.
No, where did he transfer it from? Where?
From the victim's cell phone. The victim didn't have password protection on his cell phone.
No, so that's not my question. What I'm asking, like, did he go into his banking app, or he went
like
into
his PayPal account?
Oh, so he went into the alleged victim's PayPal account and transferred it.
Yes.
Okay, all right. Thank you.
Yes, I'm sorry.
All right, Ms. Thomas, that's the only question I have. Thank you.
Thank you, Judge. I'm going to follow up on that. Is that PayPal account connected to the OfferUp account, or is that something separate?
I'm not sure. I honestly, I don't have it in my notes.
And the Steam Deck, did the victim ever get that?
No, the Steam Deck, no, he never got that. And when Mr. Nolan left, he left with Mr. Paris's scooter, a backpack, and earpods, a High Boy security blue backpack. I'm not sure. That's just the name brand, I believe, is High Boy security blue backpack, and a pair of earpods.
So he took the victim's property?
Yes.
Along with his money?
Yes.
You said earpods. I'm sorry, you said earpods, backpack, and what else?
And it was a little scooter that he drove to meet Mr. Nolan at the Mount Zion location.
Okay.
So when he got in the car with the defendant, he put his scooter in the car too?
He put his scooter in the trunk, and he said the only reason he got in the car was Mr. Nolan had what appeared to be maybe an 8-year-old child in the back seat, so he thought he was safe to get in the car with him.
And did the actual robbery occur while the child was in the car?
Yes. I don't know. Now I will say I'm not. I got a little confused because I'm not sure if that's the kid he let out of the car at the time at the build in front of building 25. I would have to go back and actually pull my actual notes from that. But I believe that's why Mr. Paris stated he got out of the car to follow the kid to see if it, because then he felt like it was a scam. Because then he started getting suspicious when the kid when the kid left the car.
Okay.
And Mr. Paris Mr. Nolan stayed in the car.
Now, could the victim determine what type of weapon was being pointed at him?
He said it was similar to a Glock. It was all black, similar to a Glock, because he knows what Glocks look like.
And was he in fear for his safety at that time?
Yes, he said he was scared to death. That's why he tried to just grab his phone so he could dial 911.
And when the defendant drove off, is that all he had was his phone?
Yes.
Did he ever get, and please forgive me if I'm repeating myself, but did he get the scooter, the backpack, or his, what was that third item? Backpack,
The earpods.
earpods. Did he get any of that stuff back?
To my knowledge, no.
Was he able to like trace the earpods or track the earpods at all?
No.
Okay. Have you ever, okay, first of all, back to the victim. How was his statements to you, were they recorded in any type of way?
They should have been recorded when the original officer responded on that, because I got it the next day. So the original officer there should be a video recording. We didn't have video recordings for us to carry on, like, body cam, because we're in plain clothes.
So did you directly interview the victim, or you just received the report from the arresting officer, from the beat officer, I should say?
1 second. I spoke with him on the phone because I got pictures of his injuries. I'm trying to remember if I went out there that day or not. Oh, I apologize, because I do. I mean, I was the only investigator, so there were so many cases that I did. So I do apologize for that. I can't remember if I went out there or not. But it's my notes right here saying that I spoke with Mr. Stanley on June 5th. But the ambulance was called for him. There was pictures taken of his injuries. That's how I seen the injuries.
And other than the 8-year-old child who was in the car, was there anyone else in there with the victim?
No.
And how were you able to identify the person that was arrested on your warrant?
I did a check of the cell phone through the messaging between the victim and the suspect. Located the name of Mr. Nolan. Also did a check with cross-reference with vehicles. The same Dodge Charger was identified as being Mr. Nolan's. I then called Mr. Nolan on the 5th, and Mr. Nolan, and stated that Mr. Paris had owed him money. But Mr. Nolan, the suspect, stated that Mr. Paris owed him money. That is why he put money on his debit card. I asked Mr. Nolan about the offer up meeting at the Quick Trip. Nolan then stated that he picked up Mr. Paris, the victim, at the Quick Trip, and that Paris, the victim, requested he take him to the flats. Mr. Paris is not familiar with the flats because he lives in Atlanta. Nolan did admit to me over the phone that he got over $2,000 from Mr. Paris. Nolan stated that Mr. Paris was not happy with the product, and that's why he wanted his money back. The initial agreement for the Steam Deck was only $350. There are text messages between them. They're in the report with pictures for that. Nolan admitted that he had all of Paris's belongings and just wanted to return the items to him. He also stated that
Did he actually return the items to him?
No.
Was he able to explain the $1,700 discrepancy?
No. He just said that that's what he owed him. He said that Mr. Paris owed him that money. Nolan stated that Mr. Paris owed him that money. But when I asked him about the offer up, then he went backtracked a little bit and stated that that Mr. Paris was not happy with the item. When asked why he closed his offer up account, Nolan stated he deactivated to prevent Paris from contacting him. Once you deactivate that account, no other you can't take any money back. Or it's the same thing as like if I deactivated my PayPal account, you can't take money back. I explained this is only common when people try to scam people out of money. And then I also told Mr. Nolan that I was going to be issuing warrants for his arrest, and he could turn himself into Clayton County jail.
Now, this conversation that you had with Mr. Nolan, was that recorded or captured in any way?
No, I believe it was on my cell phone at that time.
So that whole conversation, you didn't, there's no documentation other than your notes?
No.
Did Mr. Nolan ever turn himself in?
I'm not familiar with that because I also told Mr. Nolan that I checked his vehicle on flock cameras based off the tag, and his vehicle was off of Mount Zion and his vehicle was on Rex Road, those areas where the incident occurred.
And that was going to be my next question. How were you able to connect this defendant's vehicle to the incident and to the victim?
Because the vehicle's under Mr. Nolan.
But I'm saying, how would you able to get the tag number? Did the victim give you the tag number, or did you check the flock?
No, I checked flock.
Okay. And was the victim able to, not the victim, did the defendant confirm that the vehicle that you traced on flock was in fact his vehicle?
Yes, he did admit to being up there in the area, and he did admit to meeting the victim at the location, and that he did admit to going to the flats.
Did he ever indicate why he took the extra $1,700? What did the victim owe him for?
He didn't indicate. He just said that he owed him money.
And before this transaction, did these parties know each other to the best of your knowledge?
No.
Now, do you know where this incident started? At a Quick Trip, correct?
Yes.
Do you know Quick Trip had any video?
I did check the video over there, but it was really the manager. It kept going out while we were trying to pull it up. So I did send a request to Quick Trip corporate to get a copy of the video. I don't know if it ever arrived because I left and took this job.
You say it kept going out. Could you tell whether or not it had captured any part of this incident?
Yes, I did see a small portion of a black Charger coming in exactly on the side of the business where the victim said that he met up with the suspect.
Now, I don't think we've mentioned the victim's name during the course of all of this, but is that name documented in your warrant and report?
Yes, Mr. Paris.
Yes.
Yes.
And I believe that's all I have of the detective reserve right for redirect.
All right, Mr. Rogers.
Thank you. I guess it's investigator right now. Is that the correct title?
You know what? That's good enough for me. Okay. I'm not. You know, I'm here.
So, investigator, were you the lead on the case?
Yes, I was.
Okay. And if I'm following, I guess nothing actually happens at the Quick Trip as far as any criminal activity that's being alleged, correct?
Well, that would be outside my jurisdiction over there at Lake City. So I wouldn't be able to keep up with the stats or criminal stats that happen over there at that Quick Trip.
No, I'm just asking as far as this goes.
Okay, I'm sorry. I apologize.
Right.
No, nothing happened there at the Quick Trip. They met there and then they drove to 1885 Harper Drive, the flats.
And at that location, at the apartment, to your knowledge, is there any sort of video or anything of the incident from that location?
No, their video system has not worked there in several years. I'm going to say about 10 years. Yeah.
Understood. To your knowledge, are there any witnesses to the incident?
I did go back and did do a check of several, did a knock and talk on several doors at the building 25, and I was not able to locate another witness.
And I just kind of want to make sure I understand the general sequence of events right now. If I follow, and correct me if I get it wrong, there's the meeting at the QT, correct?
Yes,
And from there, the parties go to the flats, correct?
yes.
Okay. At some point, once they get to the flats, are you saying that, that's where I kind of got a little confused about people getting out of the vehicle. Who gets out of the vehicle first at the flats, as you understand it?
Okay, so to my knowledge, I believe it was the little kid, the suspect, Mr. Nolan, let the child out the vehicle. They talked for a minute and he left.
Okay.
So the victim, Mr. Paris, got kind of spooked at that point, got out to see where the kid was going. He then realized he did not have his cell phone, turned around and saw Mr. Nolan on his cell phone. He got concerned about that, went to grab his cell phone.
Investigator, let me stop you there. I just want to make sure I'm clear. You said he leaves his phone in the car, so when he turns and when he says he sees Mr. Nolan with it, Mr. Nolan is still in the vehicle, is that correct?
Yes.
And so then when he turns, I'm sorry, let me back up. Is the last name Paris? Or I wasn't sure if it was Paris Stanley or Stanley Paris. I'm not sure which one.
Stanley Paris, I believe.
Okay. Is Mr. Paris, he turns and he's aware that money has been taken?
No, he sees Mr. Nolan on the phone. He goes to get his phone and then sees the money is being taken. He tries to grab his phone. And that's when Mr. Nolan pulls out a weapon and points it at him to his head and says, "I'll bust a cap in you."
Okay.
He sees the gun clearly. It was similar to a Glock black gun pistol.
Okay. See, that's the part where I'm just trying to get clear. If
Yes, sir.
Mr. Paris is saying that he realizes that the money has been taken, does he realize that before he has the phone back, or like how does that come to his attention?
If I remember correctly, he said that he realizes he sees his account being open, money being transferred. He sees him doing it on the phone.
Okay.
And then he tries to grab the phone, and then Mr. Nolan pulls out a weapon and says, "I'll bust a cap in your head, bust a cap in you." And then as he's grabbing his phone, Mr. Nolan pulls off, dragging Mr. Paris approximately 75 feet.
And when
Causing injuries to his hand and feet.
Okay. And just while we were talking about the dragging part, I guess, is Mr. Nolan holding on to Mr. Paris or anything in some sort of way?
I can't actually say for sure, because I know that at that point it was pretty instamatic for Mr. Paris, and he was trying to explain everything, like grabbing the phone, holding onto the car, trying to grab his phone. He just wanted his phone because he didn't want all his money taken, because he didn't put any password protection on it. Okay.
Let me ask you like this, because I just want to make sure I'm understanding. He's getting dragged because he's holding on to the phone. Is that what's happening?
Yes, holding on to the phone. And then he lets go. He grabs his phone, and that's when he finally has his phone, is when he just lets go. And he hits the ground. I guess he's lucky he didn't get run over.
And that's why I was trying to get clear. So at any point, he could have let go of the phone and then he wouldn't have been dragged, but he just wanted to hold on to the phone, if I'm understanding. Correct?
I guess he was trying to protect his property, yeah.
Yeah, I understand. And just so I'm clear, he's doing this after he claims that Mr. Nolan has pointed a firearm at him also?
Yes, it don't happen at one time. So it's not like, oh, okay, you pointing a gun at me. So I guess it was just natural reaction for him to just hold on to the phone because he wanted to call 911. And as he's driving off, I don't know if Mr. Nolan is still holding the gun pointed at him. He's just scared and he's holding on to the phone, trying to get the phone to call 911. And then, he gets his phone and then dials 911 immediately as Mr. Nolan's driving off, as he drops to the ground. After he picks himself up.
Understood. And the conversation that you mentioned as far as having, I think you said you had a phone conversation with who you believe to be Mr. Nolan.
Yes,
Was
he
that-
did identify himself and he did clarify that he was Mr. Nolan. And he did say he did give me specifics as to what building they were in front of. He did give me specifics as to that was his vehicle. He did say that when he was there in that area. And I did tell him, and he did say that he would return the victim's stuff.
And I guess just kind of what my question is going to be is, I appreciate what you were saying about, you know, the various, I guess, kind of overlaps between the two accounts. Was there any sort of identifying info provided by the person, like as far as like a date of birth or anything, you know, that the actual person would be most likely to know?
He did say that he used, I believe he said that because the phone number I contacted him on was his secondary phone number. The phone number for OfferUp was different, but that was also registered to him as well. So that he had two phone numbers. So that he did say that was his OfferUp account. So there's two different phone numbers, one for the OfferUp account and a secondary phone number where I was able to make contact with him on.
Okay. And I understand it's been a while and what you were saying earlier, but to your recollection, is it two lines on one account or is it two separate accounts?
I don't know. I didn't check the accounts. Well, I found both phone numbers off of that TLO, the law enforcement database system that we have in order to be able to find people. That law enforcement database actually will hook you up with every car that you've ever owned, every address you've ever been on, every phone number, every date of birth you've ever used. It's just a law enforcement database that we use.
Understood. And if I'm understanding, the other items were already in the vehicle. Is that correct? That like he didn't, after the gun comes out, there's not a point at which other items get placed in the vehicle or anything like that, correct?
No, sir. No, sir. They were put into the vehicle by the victim, willingly put into the vehicle. One was in the trunk, and I believe the book pack, the backpack, and his ear pods were in the backpack, and they were in the front seat or on the floorboard.
No further questions at this time.
All right. Any other evidence or witnesses on behalf of the state?
No, Your Honor.
Mr. Rogers, any evidence or witnesses on behalf of the defendant?
No, ma'am, just argument.
All right, Ms. Thomas, are you reserving your right to go?
Yes, ma'am.
All right, Mr. Rogers.
Thank you, Judge. I guess I'm not going to go as far as to submit on the aggravated assault, but I'm going to focus my argument on the armed robbery allegation. What I will say as it relates to the aggravated assault is that the version being offered by the alleged victim, I would say it's, you know, I'm not going to say people don't do arguably stupid things in the sense of hanging onto a phone and getting dragged by a vehicle where you could be run over. But I will say that it strains a little of credulity to if somebody puts a gun in my face and then proceeds to drive off, I'm not going to hang on to the vehicle to be dragged and possibly shot. I'll put it like that. People certainly do crazy things. But with that being said, Judge, other than the fact of just the logic of it, kind of straining the credulity of it, I'll leave my argument there as far as the dismissal on the aggravated assault goes. As it relates to the armed robbery, that's more of a legal issue, Judge. My understanding, and that's why I wanted to make sure I understood the sequence of events. It sounds like all of the taking of possession of the property is already, nothing changes hands after the weapon is introduced in the situation. I guess the phone was left in the car voluntarily or accidentally, but voluntarily, not by force or anything. At that point, what's alleged is that Mr. Nolan uses the phone while Mr. Paris is outside of the vehicle. And again, no weapon is being used at that point. The reason I keep stressing that is because in Fox v. State, 289, Georgia 34, a 2011 Georgia Supreme Court case, court states there that
You said what? 289 what?
289, GA 34. And I'm gonna have some more cases for you, Judge, but feel free to stop me, but I'll have some more cases coming for you besides that one. But like I said, that's a Georgia Supreme Court case discussing what an armed robbery is and is not. There, the court talks about that the state is required to show that the use of the handgun or weapon in general, but the handgun here occurred prior to or contemporaneously with the taking. At the point that Mr. Nolan has the phone and is transferring money, the taking is complete at that point. The court goes on to say, basically in the next paragraph in the same case, we have also held in this context that the taking of property is not a continuing transaction, which ends only when the defendant leaves the presence of the victim. Or again, say is not a continuing transaction. Instead, the taking is complete once control of the property is transferred involuntarily from the victim to the defendant, even if only briefly. And that's what we have here, is that the taking of the property has occurred before the presentation of a weapon. And then there's some cases that, where courts apply that standard. One of the cases that I find, I guess, most instructive, there's a couple of them actually. One of them is Attaway v. State, 332, Georgia App 375. There, the Court of Appeals states that Attaway, he's stealing from a Best Buy. I think he's stealing a laptop from a Best Buy. That's what's going on in the case. He's making his way out. Court says that here, Attaway was already in possession of the laptop, computer, and Best Buy merchandise when confronted by employees, the Best Buy employees. Says, although there is evidence showing that Attaway used a knife in his attempt to escape the store with the stolen merchandise, there's no evidence he used a knife in an offensive manner to possess it in the first place. Again, that is not an armed robbery. One more case, but like I said, I got others, but I'll make this the last one, just not to go too long. But this last case is Mangum. This is, Page v. State. I think the alleged victim is Mangum. Page v. State, 334, Georgia App 657. In this case, gentleman is downstairs, if I'm not mistaken. The alleged victim is downstairs. The defendant is upstairs. The alleged victim does not realize, he thinks it's like a family member, somebody upstairs. He goes upstairs to see who's upstairs because he hears somebody. When he gets up there, court says, Mangum came upon Page, who was in Mangum's bedroom, coming out of a closet and walking toward the bathroom. Page was holding Mangum's wife's jewelry box in one hand and carrying Mangum's gun in the other hand. Then, to make it easy, the defendant pointed the gun at the victim. In this case, he's convicted. Page pointed the gun at the victim, told him to get out, at which point Mangum fled to another bedroom, then to the basement and outside. Again, not an armed robbery, Judge. So based on the case law there and the sequence of events, this does not constitute an armed robbery, Judge. I would concede that what's been testified to, I believe the amount would support a theft by taking, a felonious theft by taking. If the court is inclined to address to at least give weight to the gun allegation, that would be an aggravated assault following the theft by taking, but it doesn't retroactively transform what was a theft into an armed robbery. So for those reasons, Judge, I would ask that the armed robbery be reduced to a theft by taking.
All right, 88 Thomas.
Your Honor, what we have is an armed robbery. And the $2,000 that was initially taken before the weapon was pulled out, perhaps that's a theft by taking, but the remainder of the victim's property that was taken, the scooter, the AirPods, the backpack, that was done after this gentleman pulled a gun on this victim, pointed it at him, and drove off. Now, whether or not the victim intended to continue holding on to the vehicle car, I don't know if the car just pulled off so fast he didn't get a chance to let go. But whether he did or he didn't, what we know without a doubt is that this is the young man that robbed him of over $2,000 plus personal property that the victim had on him at the time that the incident occurred. Now, did this gentleman stop and give the victim back at least his scooter and his backpack and his AirPods? No, he kept going. And as of the last time the detective checked on it, this victim still had not gotten back anything. In fact, Mr. Nolan went so far as to admit most of this, including the part about turning off his can't think of the name of the site, the OfferUp, his access on his OfferUp site, so the victim couldn't even get a refund. So I believe the court has more than enough to transfer this case in its entirety to the Superior Court.
All right, based on evidence and testimony, the court does find sufficient probable cause for both charges. I mean, it's just kind of in the weeds whether the app he was transferring in real time or right after he brandished the gun. So it's enough for probable cause. So this matter is adjourned.
Thank you.
So we can bring him back.
Investigator, you're excused. Thank you so much.
Yeah, thank you for your time. I appreciate it.